I supervise the legal advocates, and I also counsel with the adults. I also stand in for legal advocacy when the legal advocates are extremely busy. When people first come into our agency, we determine, what their needs are after speaking with them. Sometimes it's just counselling, and when I say counselling, I mean domestic violence education, because we're not mental health counsellors, because even though domestic violence victims may have mental health issues from the abuse, they don't have mental illnesses in general, although they can develop those after time. If they want an order of protection, what we do, it's the Illinois Domestic Violence Act, and they've got to fit certain criteria for an emergency order of protection where, there has been pretty recent abuse. When they do that, they have to fill a petition out, and then the emergency order itself. And then we get a date for the judge, and we go in front of the judge with them. Although we can't speak for them, we're there for support only. And if they're granted the emergency order of protection, they then can go back for what we call the plenary order of protection, which is a 2-year order. During the emergency process, they go in front of the judge and tell the judge exactly what happened. And for their own safety, the respondent is not notified because it's very dangerous. Once they obtain that emergency order of protection, then the respondent is issued with the petition, the emergency order of protection, and a summons to go back to court. They do not have to go back to court. They do not have to show up at court, however, because the petitioner will just automatically be granted the order of protection if that's what she still wants. If he does show up, he can bring a lawyer, he can represent himself, and at that point the two parties both present their sides, and then the judge decides from there whether he will grant the order of protection. But you can just go for the plenary by itself, you don't have to go for the emergency order.